Hi, I'm Janice Switlo, and today I want to reference a book and some quotes to really emphasize why this Section 35 doctrine and going into courts, why it's not the answer. So capitulating, abandoning, and saying I'm under Canada and that's all there is. I want to point out and share some quotes that hopefully will emphasize to you just how dangerous that doctrine is, even more so than what I've described already. This is from a book called Trudeau and Our Times, Volume 1, The Magnificent Obsession. It won a Governor General's Literary Award. And this is about Pierre Elliott Trudeau, who was Prime Minister and, of course, father of our current Prime Minister of Canada, Justin Trudeau. So forgive me because I just need to, there's about 4 quotes here and I just have to kind of find them on the page. But let's, first of all, emphasize here. And it's a discussion about Bora Laskin, who was the Chief Justice of the Supreme Court of Canada. And it says, during the 7 years he had been Chief Justice, he, that's Bora Laskin, had presided over the Supreme Court's transformation from a relatively minor factor to a central institution in Canada's political landscape by boldly asserting its importance as another branch of government. So when you're going into the court, the Supreme Court of Canada in particular, it's seen as being a branch of government. So really think about that, what you can expect in terms of the decisions of an arm of government as against another arm of government. I mean, talk about, the dice stacked against you, So think about that one. As well, I want to share with you that the strategy that is in play against you is one that Trudeau Sr. Trotted out when he unilaterally proposed the Constitution Act 1982 to, repatriate the Constitution, however he described it. It was a unilateral act, and there were 8, they were called the Gang of 8 at the time because there were 8 provinces who were not in agreement with that. And there was a question put to the court, Supreme Court of Canada, to say, can he proceed unilaterally? And the court said, I don't know. What basically said, well, you need at least substantial support of the provinces. So he knew he couldn't proceed unilaterally. He had to get some of these a Gang of 8 on board so that he could then proceed to London to try to make this happen. So what was his strategy? Okay. The slogan for the week in dealing with these various premiers, the slogan for the week was not, quote, divide and conquer, end of quote, but, quote, conciliate and prevail. Think about this strategy of, quote unquote, reconciliation. It's this same effort. Conciliate and prevail. Dominate. This isn't partnership. This isn't a shared responsibility. This is not nation-to-nation relationships. It's a tactic. It's a way to convince you to come under so that Canada can prevail over the Indigenous nations and prevail over treaties, as opposed to being answerable to the Indigenous nations and answerable to the treaties. Bear with me, another quote I want to share and comment on from the same publication. One of the premiers of this Gang of 8 was Saskatchewan Premier Alan Blakeney. And his issues with how everything was shaping up in terms of Pierre Elliott Trudeau's efforts regarding the Constitution. His concern was, he said he disagreed with the federal NDP's support for a charter, fearing it would subordinate the people's will, as expressed by elected politicians, to the reactionary whims of judges recruited from the wealthy legal profession. Well, that's exactly, his fears are exactly what happened in terms of Section 35 of the Constitution Act 1982. That's exactly what happened. And I've set out the episode, Section 35, the plan, explaining the history of how that came to be and how it was put in place by a hand-selected justice that Pierre Trudeau put in place. And I want to emphasize, when I was just speaking about the Wet'suwet'en situation, and I mentioned the BC Civil Liberties Association or organization, said, well, hey, this is a charter matter. Please, this is an international matter, to emphasize again. It is not a matter that can be handed into the hands of, the wealthy, selected, the whims of judges recruited from the wealthy legal profession that are politically in tune with those who have appointed them. The charter does not apply to Indigenous nationals. And then I have one final quote from this. It brought to mind, this publication, it brought to mind something to share with you. And that is, and this time frame of all these goings on was like 1980, 1981. The Constitution Act 1982 happened after that. So at the time, there was High Commissioner in Canada, Sir John Ford. He was a senior British diplomat in Ottawa. And he became very actively involved and concerned with what was going on. And it was driven by, quote, his belief that Trudeau might be capable of declaring Canada a republic. Now, I have discussed earlier in episodes how, or maybe Facebook posts, where I've said, look, what's going on here seems to be a kind of revolution, going beyond even the aspects of outlaw nation that I have pointed out before. And coming across this, to know that someone of his stature was looking at the current situation and felt that the agenda was to move towards a republic. And then I look at what his son is continuing with today, and you put together that with the fact that if you have a revolution and you have the formation of a republic, then all the treaties fall, because that becomes then a successor state, and the successor state is not bound by the treaties entered into by the former nation. Wouldn't that be a handy solution? But here's the complication. If Justin Trudeau cannot get the Indigenous nations to sign in and say they're under Canada, and therefore terminate the treaties, allowing then the Crown to pick up all of it and own it, then when Trudeau tries to establish the Republic and kick the Crown out, he's and basically going to war with the Crown. He doesn't have this aspect of a conclusion where if he goes to war with the Crown, he has no land. He's going to take the land from the Crown. Right now, all he can take from the Crown is this partial political sovereignty. The rest of the stuff is all in the hands still of Indigenous nations. But this is why his plan to very quickly, through passing of, I've talked about this before, passing of election codes and constitution acts, and I'll be dealing specifically with an Anishinaabe situation in 2 long broadcasts that go through the entire final draft that it was finally put in my hands, and I commend the brave individual who was able to obtain that, because not even chiefs are able to get that document. Why? Because under that agreement, they don't have to give it. anyhow, that's a little preview of what's to come on that. So think about that. What kind of an environment are you going into and expecting to be dealt with appropriately? Remember, Indigenous nations subject to international law, provided that the whole do not agree to abandon and give up and hand over and say, you're right, my ancestors were beasts of the field, we never did own this, we never could own it, we weren't sufficiently evolved as human beings to do so, therefore we agree that, Mr. Trudeau, when you Pierre Trudeau, when you brought that Constitution Act 1982 into effect and brought it over from London, somehow we were absorbed into you as well. You know how I feel about that. It's a crock. It's a lot of schlock, and it's just not true. So think about that next time before you utter something about Section 35 or Delgamuun.